Okay, welcome everybody. Those of you who don't know me, I'm Jim Anaya, the Dean of the Law School. We're here to discuss pressing matters that have come to the fore in the last 3 weeks. Indeed, the last 3 weeks, I think it's fair to say, have been quite historic in the country for many events and initiatives taken by the present administration have been jarring and have caused a great deal of concern on a personal level to many in our community and around the country. And also, deep policy issues are being raised by many of the actions being taken by the current administration that deserve being addressed. I'm very proud of our faculty, and particularly those who have come forward to offer to address these issues, to lend their expertise, their considerable expertise, to addressing the concerns that are arising from this milieu we find ourselves in today. We're not here to preach one particular political point of view, but simply to provide information and insight into what the recent executive orders and related actions on the part of the administration mean from a technical standpoint, and also what they might mean going forward, and the kind of implications that they have for people within our community and beyond. So I want to thank the members of our faculty who've come forward and offered to lend their expertise to addressing these matters, and also to Associate Dean Eric Girding, full Professor Eric Girding, who's going to moderate the discussion. So I'd like to turn it over now to Professor Girding.
Thank you all for coming. The events in the last couple weeks, as Dean Anaya has mentioned, have been extremely surprising, and I think for many members of our community, concerning, and have generated quite a bit of questions and in some cases fear. So we wanted to bring together a lot of the amazing resources that we have in the building, who are experts on immigration law, constitutional law, ethics, regulation, to shed a little bit of light on the immigration orders. So the way that we're going to proceed is Professor Violetta Chapin, who runs our Immigration and Criminal Law Clinic, will start out talking about how some of the president's immigration orders actually work, starting with the ban on visitors from 7 countries. But not only that order, but a number of other orders as well. Professor Chen, who has a great deal of experience in immigration and citizenship, will then add some color and thoughts on other immigration orders that are in effect. Professor Megan Hall, who teaches legal writing here and who comes to us with a background in practicing immigration and refugee law, will also talk about her perspectives on the immigration orders. Professor Cantrell will talk about some of the ethical dilemmas that government officials are facing in interpreting and implementing or not implementing these orders. Professor Reed, who also works in our clinic, will talk about some of his experiences going down to GIA on the weekend that these immigration orders came out. And Professor Dana Matthew will join us a little bit later. She is one of our constitutional law experts, and we'll talk about some of the constitutional challenges to these immigration orders and a lot of the constitutional concerns behind them. We're going to try and keep the spoken portion of the prepared remarks fairly short to allow plenty of time for Q&A. As we move to Q&A, I should say that we're all lawyers here, so we have to be very careful about the rules that govern lawyers, and we're not going to be able to provide legal advice or make referrals today. But hopefully a lot of the insights of our panelists will be useful for you all nevertheless. So Loretta, you want to take it away?
Thank you. Hi, everyone. So this is actually the second of 2 teach-ins that we've done on this particular topic. We had a much larger one downstairs in the Whittemire courtroom, I believe, last week. So thank you guys all for being here. But since we have a smaller crowd, I would love to hear who you guys are. So if we could just quickly go around the room and just let us know who you are. Like, are you at the law school? Are you at a different school? And sort of what you're hoping to get out of this here today. So we can start with you in the back.
My name's Joe. I'm a 1L. I just was curious about some of the things you guys are going to be talking about.
Great. Thank you, Joe. Sir?
I'm an alumnus, class of 77, but I'm retired.
Great. Thank you.
Oh, I work here. I'm an assistant dean for admissions. I'm the director of international student scholarships.
Also, PhD candidate, civil engineer.
Great.
Experience there.
Thank you.
Professor in electrical engineering with interest in both people's and his
Okay.
Hi, I'm Natalie. I'm a journalism student here at CU, and I'm actually doing a whole story relating to immigration orders. I'm Fernanda Loza. I'm a 1L. I came to the other talk. My name is Erin Orsley, and I went to a talk that was hosted by many of these panelists back in November in Singapore.
I'm Norm Erickson, and I teach in the clinic. My students are doing asylum cases, especially people with status.
I'm Leanne Burnett. I'm an adjunct faculty teaching aviation. I'm Kristen Carpenter. I'm an associate dean and professor of law.
Richard Chadden, I'm a trial lawyer and very interested in how this might affect Cuba. I arrived in Cuba the first time swimming. I've been there many times since. And now I'm there under a lot of executive orders on a regular basis. So it'll be interesting.
Thank you. Okay, so like Professor Girding said, we're going to talk about some of the executive orders that have come out sort of fast and furiously since January. We're going to talk mostly, or at least the portion of my talk is going to talk about the order banning people coming from 7 designated countries, as well as stopping the entry of Syrian refugees. So, but just to get us started, we'll go through sort of the 3 that were signed, all 2 on January 25th and 1 on January 27th. The first one, enhancing public safety in the interior of the United States, will be addressed a little bit later by Professor Hall. Border security and immigration enforcement improvements was the one mostly focused on the building of the wall along the U.S.-Mexico border. And then I'm going to focus mostly on this third one. And as many of you know, I guess if you've been reading the news, there have been a lot of rapid fire developments on this, the most recent one coming this past Friday. It's not over yet. I imagine it's going to be appealed to the Supreme Court, but I'll talk a little bit more about how we're going through the trajectory. So this one in particular signed late on Friday afternoon, right? So it sort of came as a surprise to a couple. I'm going to focus mostly on Section 3, subsection C. And as you can see, the text of that paragraph is there. And this is the paragraph that banned entry from the 7 countries. Referring specifically to Section 212F of the INA, this is the first of many uses of this extraordinarily broad provision of the INA that is repeated many times throughout the text of the order itself. It gives the president broad authority to suspend the entry of any aliens or any class of aliens through a proclamation that such entry would be detrimental to the interests of the United States. And a lot of legal scholars are thinking that this is going to be the main problem for the people who are fighting the ban, right, for the state of Washington and Minnesota, really, when this case goes up to the Supreme Court. That the executive authority, the executive really truly has an extraordinarily broad power to do this. This provision has been in the INA since 1952, but the use of it has always been much more focused than what we see in the order. So for example, in 1999, President Clinton used it to suspend entry of Serbian government officials who were responsible for the repression of civilians in Kosovo. It was also used under President Obama in 2011, who suspended the entry of people who were subject to UN travel bans, which were generally related to human rights abuses. We thought about using it after the 9/11 attacks, right, which everybody remembers, of course, but it didn't end up happening. So that, sort of the broad use of this to ban an entire group of people from an entire country is the first time that this has ever been done in this way. With respect to, you see also that here it doesn't mention the 7 countries. It refers to them sort of cryptically in section 217.812 of the INA. And those countries were actually added under the Obama administration. So President Obama listed those countries. Section 217.812 specifically was recently passed in 2015 after the San Bernardino shootings. And what it did is it imposed additional restrictions on travel to the US by people who had traveled to regions of the world that had a significant terrorist presence. The statute specifically names Iraq and Syria, and since then, 5 others have been added, which is Iran, Libya, Somalia, Sudan, and Yemen. Okay, so Trump didn't come up with these countries on himself. These were put in there by Obama. He's using them in a different way than President Obama did, but they were already there. So obviously, so it was unclear here, at least initially, whether or not this particular section applied to lawful permanent residents. There was some internal back and forth, according to press reports. It turns out that it doesn't, and John Kelly, the Department of Homeland Security Secretary, has now made it very clear that this does not apply to lawful permanent residents. And so after some initial sort of mishaps and chaos, really, at airports across the country, it was clarified that it does not apply to LPRs. And then the bottom ones, G1, G2, G3, and G4 visas, those are diplomatic visas. As I just said, multiple LPRs were detained briefly at US airports. There were some people who were pressured to sign Form I-407's record of abandonment of LPR status. Then on Sunday, January 29th, Secretary Kelly stated that it would not apply to lawful permanent residents, and that LPR status would be dispositive of them being able to enter. So then section 5, did you want to talk about that, Professor Chen?
So when we did our teach-in last week or 2 weeks ago, there were some questions about this provision, which hasn't been getting as much coverage or attention in the news, but I think is also important to mention, and it's also affected by the recent temporary restraining orders that have been put on the executive order. Section 5, as you can see from the slide, does 2 things primarily. One is that it suspends the US Refugee Admissions Program for 120 days. And to be clear, this extends far beyond the 7 countries that are listed for Section 3, which Professor Chapin was just speaking about. So this is the entire refugee admissions program for that 120 days. If you are curious to know, the top 15 countries that sent refugees last year in fiscal year 2016 were the Democratic Republic of Congo, Syria, Burma, Iraq, Somalia, Bhutan, Iran, Afghanistan, Ukraine, and I can keep going through, it's mostly some other African countries and Pakistan. So if you're thinking about the other countries that might be affected by this provision, that gives you at least a flavor of that. The next provision is the one that you probably have heard a bit more about, and this is an indefinite suspension of the entry of nationals from Syria as refugees. And one of the things that's worth noting is that in the earlier version of this executive order that had been leaked to the press before it was signed, there had been the establishment of certain safe zones where Syrian refugees might be able to reside if they were not going to be allowed into the United States. That's not included in this provision. Which I think is at least some of what raises concerns about the international humanitarian obligation of the government in blocking the admission of refugees. Another provision here that is interesting is that this would impose a new cap of no more than 50,000 refugees in fiscal year 2017. Again, just to give you a little bit of context, in the year preceding The United States obligation was we had accepted about 100,000 refugees, so this would cut our prior obligation by about half, despite the fact that there have been a number of migration crises in parts of the world, including those affecting Syria, that actually might increase the number of people who would be seeking entry through these channels. The last provision is a little bit curious. What it asks is that state and local governments be granted a role in the process of determining the placement of refugees in the settlement, in their settlement within the United States. That would be relatively new to the way that the refugee resettlement program has worked in the past. I think the speculation is that Vice President Pence, who in his former role had participated in the filing of a lawsuit against President Obama's increase in the number of refugee admissions for the prior fiscal year, out of concern about the ability of his state to absorb refugees, might have had some influence on this provision, but because it is sort of new and because it largely hasn't been implemented, it's hard to know what it would exactly mean. There's just one or two points that I wanted to make about these particular slides. One is that we've already mentioned is just the effect on Syrian refugees in particular, given the circumstances they're in. Recognize again that many of the people who were initially barred entry were people who had already gone through a fairly extensive vetting process that determined that they were entitled to refugee protections, again, under US and international law. The concern then is whether or not those goals would be compromised without a clear benefit in terms of evidence that the refugees that are coming from these countries would necessarily pose national security risks. You might know from some of the lawsuits that have transpired over the last few weeks, including the Ninth Circuit decision in oral argument last week on the temporary restraining order, that there is very little evidence that the people who came from these countries were themselves terrorists. With a lot of the references have been to 9/11, and a number of the 9/11 terrorists were here on non-immigrant visas. However, none of them were actually refugees. One of the other areas that I had wanted to highlight in terms of a potential impact for these provisions is the impact on Central America. One of the other global migration crises that we've been hearing about in the news a lot is the Central Americans, mostly coming from Guatemala, Honduras, El Salvador, who have been fleeing violence in their home countries, seeking resettlement in the United States. And many of these are unaccompanied children or minors who have been coming to the United States. The United States response has been sort of complicated inside the country, but one program that had developed in order as an alternative or a preference, I suppose, to the predominant means, which has been the heavy use of family detention in order to hold the immigrants who were coming from Central America, was this overseas refugee processing. And so they too would be impacted by this particular provision and no longer being able to enter the country. Over the weekend, there were some stories that with the temporary restraining order, that there has been I guess there are conflicting reports on whether there's actually been an uptick in the number of refugees who have come in while this provision has been put on hold. There have been people who are coming in, but to be clear, those are all people who had previously been vetted and are coming in through that process. I will turn it over to Professor Paul. No, I will turn it back to Professor Chapin, who's going to tell us a little bit more about those lawsuits I just mentioned.
Right. So the executive order comes out, and then obviously this is what happens, right? This is one of the things that immediately happens. Hundreds, if not thousands, of lawyers descended on airports, right, across the country. Blake and I went to DIA to see what was going on. There were like 28 lawyers standing at the International Arrivals Gate. It was just tremendous and amazing, and I was really, really just pleased to see that lawyers were lawyering and out there really trying to be helpful and trying to see the free lawyer. I've always been a free lawyer. I'm always happy to be a free lawyer. And there was an immediate response to these orders from the legal community, as well as a number of just advocates, sort of people in the community. We had interpreters show up at the airport at DIA hoping to help. There were people who were just concerned, from social workers, people who work with children, teachers. I mean, just a tremendous response from people wanting to not just help, but also to just be there to witness. And then, of course, there were some lawsuits filed. They came fast and furious. I was shocked at how quickly the lawyers in New York managed to get that out there. And so you had these lawsuits filed across the country seeking to stop the travel ban from working at all, and also trying to get their clients out, sort of bodily and physically out of the airports where they were being held by Customs and Border Patrol. The judges agreed, temporarily stopped enforcement of the EO. Just briefly, this is the lawsuit that came out of JFK, Darwish versus Trump. It was a petition for writ of habeas corpus to try to get his body out of the airport. Just a brief discussion about who these petitioners are. Mr. Darwish had been issued a special immigrant visa just a few days before because he had been working for many years for the United States military, a great danger to himself and his family. He had been vetted through a very rigorous process to ensure that he was not going to himself pose any threat to the United States, and he was in possession of a valid visa already. Mr. Al-Shawi was also granted a follow-to-join visa even a few days before Mr. Darwish to rejoin his family here in the United States, who had been granted refugee status themselves, again, due to their family's association with the United States military. So they were quite sympathetic plaintiffs to begin with. For the lawyers in the room, these were the grounds that they alleged under the Fifth Amendment, alleging violations of their procedural and substantive due process rights, and their rights under immigration statutes to apply for asylum and other protections. Federal District Court of New York, this was the first judge. She ruled just before 9 p.m. on Saturday. So there's all this activity happening in the courts on the weekend, right? And these sort of emergency motions will be responded to very quickly. And she decided that she was going to stop it, that implementing the order would cause irreparable harm. And she stopped the government from removing individuals who had already arrived in the United States with valid visas or refugee status. This is where other lawsuits were filed. Washington State and Minnesota are highlighted because those are that was where the case went up to the Ninth Circuit. But you can see that there was also a nationwide lawsuit filed by the American Immigration Council and all of the other folks who helped. On Sunday, we got a position from the Department of Homeland Security stating that it would continue to enforce the executive orders even while complying with judicial decisions. And I highlighted that last part because I think that really has been the Department of Homeland Security's position, and it will remain that, right? Which is the people who are in favor of this ban do believe firmly and deeply that they are protecting the safety and interests of the United States. And the Department of Homeland Security is tasked with doing that, despite all of these legal objections coming from right and left. And so that is going to be the position of the administration, that all they are trying to do is to ensure the safety of everyone and all American citizens in this country. Okay, so then more lawyering happened, as many of you know. The Justice Department appealed to the Ninth Circuit and asked them to enjoin the emergency stay. So essentially say, lift it, let us do what we want to do until it gets litigated through the courts. We may win. That was denied. And then on this, just this past Friday, a 3-judge Ninth Circuit panel, politically diverse, delivered an extraordinary rebuke to the Trump administration and rejected just about every single argument put forward by the Justice Department and left the temporary restraining order intact. So the travel ban has been stopped as of now, but obviously it will likely be appealed to the Supreme Court, but we're still in a position where we have 8 justices, so we're not quite sure what the result is going to be out of that. And then I had to include my favorite meme. I just had to. Okay. After just losing in court. Okay, so now Professor Hall is going to talk about the executive order enhancing public safety in the interior of the United States.
We'll see you in court.
Yeah.
All right. So now I'm going to shift a little bit and talk about one of the executive orders that was actually signed before the travel ban. And this one is called Enhancing Public Safety in the Interior of the United States. So as the title suggests, whereas the travel ban talks about who can come in, this talks about how the laws are going to be enforced for people already inside the United States. This order has 18 different provisions, but for now I'm going to focus on 4. All 18 of them have interesting features, but we have limited time, so I just want to hit these key points. So 4 things that this order does. First of all, it drastically changes the priorities regarding who is targeted for deportation. It calls for ICE, Immigration and Customs Enforcement, those are the immigration cops, right, to hire 10,000 additional deportation officers in order to enforce the law under this new priority system. It imposes sanctions, including federal grant cuts, federal funding cuts against localities that are designated as sanctuary jurisdictions. And a 4th thing that it does is it encourages federal state agreements, which are called 287G agreements. That's a part of the Immigration and Nationality Act that permits them. And basically that makes local cops into immigration cops. So let's talk briefly about each of these 4 things. So first of all, just to highlight what a big shift in enforcement priorities this executive order represents, I want to look at the priorities that were in place before the order was signed, and then contrast them to the priorities that are in place now under the order. So the old enforcement priorities, and these were issued under the Obama administration in November 2014, were as such. So basically, ICE was instructed to go after the most serious offenders, not just undocumented people here working and raising their families, but people who had done something to trigger some scrutiny. So the highest priority level was people posing a threat to national security, border security, and public safety. So these were people engaged in terrorism, espionage, gang activity, people with serious criminal history, like a felony, and those apprehended at the border attempting to enter. Now that is debatable whether that really fits in that category, but as Professor Chapin noticed, we were experiencing this surge of people fleeing violence in Central America. And so some of these provisions targeted at recent entrants go to that. But by and large in this category, you have people who have done something, that could be perceived as anti-government, anti-social, something dangerous. Now, whether crimes should be linked to deportation is a whole other can of worms. We could have a whole other discussion about that. But in my opinion, at least this system made some sense. There were clear priorities that were linked to certain goals. Second goal is people with serious or multiple misdemeanors. And then again, we see new immigration violators, people who had recently come in and broken the law. Then the lowest priority was people with deportation orders that hadn't been executed. So people who had been ordered deported, but had not actually been deported. And that was the lowest level. And as someone who was working in immigration detention, representing people at this time, when these priorities went into effect, ICE very reluctantly followed them. And we saw a huge shift in terms of who was being detained at the Immigration Detention Center. Then we have this executive order, and it just completely upends the old priority system to the extent that many advocates have said, well, there really isn't a priority system anymore. Anybody can fall under the ambit of this new executive order. So people convicted of any criminal offense, regardless of what the offense was, when it happened, or the circumstances, are identified as priorities. And a well-known immigration lawyer named David Leopold has said, so this basically equates a traffic ticket with a murder conviction, right? And it's a blueprint for mass deportation. It's extremely broad. People who haven't even been convicted of a crime, but have just been charged with a crime that hasn't been resolved, now fall under this system of priorities. So think about how broad that is. All a cop has to do is issue someone a citation, and bam, they're an enforcement priority. People who have broken a law, who have done something illegal, but haven't actually been charged or convicted, even broader. People with deportation orders. So we saw that under the old priority system, but the old priority system targeted people who had recently been ordered deported and hadn't left. Now, anybody with an outstanding deportation order, say that somebody missed an immigration court date 20 years ago because they didn't get notice. They've been living here ever since, they've been working, they have kids who are citizens. Now they fall under the new priority system. And then this huge catch-all. Anyone who in the judgment of an immigration officer otherwise poses a risk to public safety or national security. So that gives a lot of discretion to an individual immigration officer deciding whether to take someone into custody. Does this person pose a risk to public safety or national security? That officer can probably come up with a reason that the answer is yes. So we've seen this huge expansion in enforcement priorities. And this is something that unfortunately I don't think probably is going to be subject to litigation because here we're in the arena of discretion, right? Anyone who's here in violation of the federal immigration law can be arrested, can be taken into custody, can be placed in deportation or removal proceedings. But what we've seen up until now is that wasn't happening. There weren't the resources. It just is really not possible to enforce the law against everyone. Now it kind of is. And so tagging along with this, the hiring of 10,000 additional deportation officers to carry out this plan. So we're going to see a vast expansion, I'm afraid, of immigration detention and just a huge increase in the number of people going through immigration removal proceedings under these new priorities. Now, another thing that this executive order does is it imposes sanctions for cities and counties, jurisdictions that are sanctuary jurisdictions. So what does that mean? Well, nobody really knows. There's not like a particular legal definition of the term sanctuary jurisdiction. It's really a spectrum or a collection of actions that a locality decides to take to protect undocumented people, immigrants living in that community. So some examples of actions that could constitute sanctuary include rejecting detainer requests or ICE holds. And what that means is that a lot of times ICE asks a county jail to hold someone until ICE can come and pick that person up. So the person is in jail on state or local charges, maybe serving a sentence, and ICE can lodge this thing called a detainer saying, hey, instead of letting that guy go at the end of his sentence, we want to come and talk to him. We might want to take him into custody. So why don't you just hang on to him for 48 hours until we can get over there? In Colorado, as of 2014, no Colorado county was honoring these detainers under threat of litigation. There have been some federal lawsuits saying, you can't do that. That violates the Fourth Amendment if you continue to hold this person. The Colorado backed off. No detainers were being honored anywhere statewide, and that was a huge victory. But now, this executive order seeks to punish localities that are doing that are essentially complying with the Fourth Amendment. Other protections that can fall within this realm of sanctuary protections include a locality telling police officers not to ask people about immigration status, offering municipal ID cards to undocumented people, so that's more of like an affirmative protection. Here's a card that you can use if you're asked for ID. And even providing legal defense to non-citizens in deportation proceedings. So deportation proceedings are civil in nature, they're not criminal. There is no right to counsel at government expense. People have to find their own attorneys. But some localities like New York City, Washington, DC have decided to fund lawyers for people in the removal proceedings. So there's this whole range of protections, right? But what this executive order really hones in on are two things. There's a provision in federal law that says that localities have to communicate with the federal government when the federal government wants information about someone's immigration status. So the executive order says that if a locality isn't doing that, then they can be sanctioned. But the order also says that the Secretary of the Department of Homeland Security gets to decide what is and what is not a sanctuary jurisdiction. So we'll see how that plays out. Now, the city of San Francisco, which has proudly proclaimed itself a sanctuary city, has already sued the government over this. And so they're arguing, first of all, they're already complying with what they need to do under the order. They're communicating with the government, even though they're not providing these other forms of cooperation. And they're also making some constitutional arguments. So that's another lawsuit going forward. I think it's getting a little less attention because the travel ban has been much in the news, but we'll see how that plays out. So as I said, the order threatens sanctions against sanctuary jurisdictions, and that's what San Francisco is worried about. They are worried that they could lose their federal funding, which is considerable, if they continue to do what they're doing. But one thing I want to point out, and I don't mean this to scare anybody, but I just think it's really important to understand, the aggressive enforcement actions that we're going to see don't really help people, even people living in a sanctuary jurisdiction. So I just think it's important to note that. If ICE wants to get people, ICE will find a way to do it, right? So I'm not saying that sanctuary cities aren't helpful or that that movement is not powerful or that that doesn't do anything, but I just don't want anyone to think, oh, well, if you live in a sanctuary city, if you're in Boulder or you're in San Francisco, you have nothing to worry about. And we saw this in Colorado when counties stopped honoring detainers in jails. ICE didn't just say like, oh, well, now we can't use detainers anymore. We're just gonna give up and go home. You know, we'll just empty out the immigration jail. No, they just started finding other ways to look for people that were not reliant on local cooperation. And so they started waiting for people outside the jail. They started waiting for people outside of court. So they would go to court for an arraignment and walk out and be detained. They were going after people in halfway houses. They were going after people in their homes. And we just saw, you probably heard news over the weekend of major ICE operations targeting hundreds of people. You know, ICE is saying that that's not in reaction to this order, that that was a pre-planned operation. I think that's possible. You know, even under Obama, we saw a lot of these ICE operations, which usually have some ridiculous name like Operation Wildcat, Operation Eagle Fire, and they would, you know, go after a certain class of people. It could be that that's the case. But my point is it was happening before. It's certainly going to continue now. So I just don't want anyone to think that sanctuary jurisdictions are the solution. I think it's definitely something that's really important, and those protections are valuable. And even just a city coming out and saying, we support our immigrant population, that's very valuable, but it doesn't mean that people in those communities are not vulnerable. Quickly, I just want to mention this idea of 287G agreements. And this is basically the opposite of a sanctuary, right? So what this does is if a locality wants to enter into one of these agreements with the federal government, then local cops in that area, in that jurisdiction, are deputized basically to be immigration officers. So they're trained by ICE to do the things that ICE officers do. So when they're encountering somebody on the street, they are wearing two hats. They're a local cop and they're an immigration cop, right? So these had basically died out under the Obama administration. A lot of these agreements expired and the administration decided not to renew them because they were not working. They were not effective. A lot of counties did not like them. There were a lot of complaints of racial profiling, misuse of local resources for federal law enforcement. They weren't catching a lot of violent criminals. They were making people feel unsafe in their communities. People started to distrust law enforcement and didn't want to report crimes or ask for help. So they were phased out. This executive order says that every single governor is going to be approached and basically asked to enter into one of these agreements. They don't have to, but the gist of the order is clear. This is what the Trump administration thinks should be happening. And then briefly, I think we'll talk a little bit more about this at the end, but there's also a sanctuary campus movement that started in response to Trump's election. And what that is, I'm sure you've heard about it, it's basically the equivalent to a sanctuary city. Students have been walking out, protesting, demanding that their colleges and universities designate themselves as sanctuary campuses. And as with the sanctuary city, the problem is there's not really a clear definition of what that means. So a lot of the student groups have a clear list of demands, things that they're asking for, but there's not one model, right? But some of the things administrators have done or are considering are things like refusing to allow ICE agents to come on campus without a warrant, or at least not to go into private areas like dorms, refusing to share students' information on a voluntary basis, advocating for the preservation of DACA, the Deferred Action for Childhood Arrivals, offering financial support to undocumented students who might not qualify for federal financial aid, and offering advising and immigration legal services to students. So that's kind of a parallel to the Sanctuary Cities movement. Yeah, I think I'll end there and turn it back over to somebody.
I think in the interest of time, I'm going to defer to colleagues and open and let us go to questions. But let me just highlight that one of the things we hope to do, and if it is of interest to those who are in the room, is to highlight the campus impact of some of these executive orders. So maybe we can come back to that. I'll leave this slide up so that you can see it, but I'll.
And I think we should just go ahead with questions because some of us do have to leave at 5 and to make sure that folks in the audience get the benefit. So.
My question is, what's the probability that, say, the campus refuses to identify a student, they just cut off all research funds for the campus?
I think that's one of the worries that people are expressing, trying to figure out what kind of executive power is going to be deployed. And I think we need to be very cautious about speculating about that. So the question is going to be, who's got the right authority? So does the executive, the president, have authority to do what he's claiming? Is it cabined in some way by the Constitution, right? This is our basic separation of powers argument. Is it cabined in some way by Congress and legislation it's passed? So I for one, am going to be pretty cautious about speculating, although that's everybody's worry.
And there are FERPA protections that are already in place to protect students. So the school cannot just hand over information about students willy-nilly. They have restrictions under FERPA and they cannot provide that kind of information anyway.
The question, I think, though, is really, this is the separation of powers argument. Okay. What authority does the president have? Will it come into conflict with statutory authority? Is there some argument the president has to work around it? Where are the constitutional protections? And these will be heavily litigated, I anticipate.
Right. And certainly for the funding, the yanking of the federal funding, the Affordable Care Act case that came out sort of under, the Republicans challenged under the Obama administration made it clear when Chief Justice Roberts refused to implement the expansion of the Medicaid extension, it was because you can't take federal funding away from states for refusing to do something that wasn't there in the first place that ordered them to do it, right? And so there's that, and then there's the anti-commandeering part, which says that the federal government can't force the states to do things that the federal government wants them to do just because the federal government wants them to do.
So Fiona is a lot more hopeful than I am.
Right.
That could be blocked. I actually.
I think the weakest campus in the country that would have to cave in because even if we kept them shut down for 2 months, they'd go bankrupt. You just pick the weakest one and knock them out.
Yeah, no, I hear what you're saying. That would have to also go through its process though, which is the government would say, I'm going to try to pull your funding. They would object legally to them doing that. It would hopefully be enjoined while they're trying to work it out. But you're right. It's hard to speculate about what's happening, but there would certainly be a legal response to that.
Yes.
Yeah. And also federal funds are not the primary source of funding for most of the public universities.
Well, it would knock them off. It would certainly knock a big hole in our budget when we get 4 or 5% from the state.
Yeah.
It probably knocks about 30% of the budget of the campus out the door. Something of that order, 20 to 30%.
I don't know what of the total campus budget, what are federal grant monies, combined also then with questions about how people pay tuition and whether you get federal funding, right? There are all sorts of pieces, puppet strings that get pulled. So
sure, there are a lot of strings, but I was thinking if you wanted to hit somebody to make people jump, that's an easy way for the federal government to act.
So one thing that Violetta said that's really interesting here is, in some ways, federalism is a friend of progressives in this case, because the federal government can't commandeer state and local governments to do whatever they want. So there are constitutional doctrines. There's also constitutional doctrines on unconstitutional conditions that you can place on federal money. So we're not saying that's going to win the argument in courts for universities, but this will be heavily litigated.
Yeah.
And let's observe too, there's a political context in which any of this would play out in before we get to court. So I know we're a bunch of law professors, and our inclination is to think about how this is going to get fought about in court, but the idea of the president unilaterally yanking a bunch of money from science to pursue an immigration enforcement agenda is not something that's going to go unnoticed in DC. So I would hope we'll see you'll see it coming before we get to any of the stuff that we're talking about here.
If the governor within state signs a treaty, I assume that would automatically bind like the state police department, but how would all local municipal police departments be bound by that automatically? How would that work?
Do you know how that works? I feel like the ones in Colorado that I know about have been negotiated directly with local law enforcement, and then those agencies, at the county level. So like, there was an agreement between the federal government and the El Paso County Sheriff's Department, and then El Paso County decided they didn't want to renew it, that it wasn't a good use of their resources. So the language of the executive order talks about Homeland Security contacting the governor governor of each state, but I guess my assumption would be that the agreements would be more at the local level.
And just remember, in Colorado, we have home rule. So that's the interesting piece here, right? That cities, other municipalities can designate themselves as home rule, where they can cover the space in a way that states ordinarily would, although we have the same kind of thing where a state can preempt. And so it would be very interesting to see how this plays out, because you've got home rules. You've got lots of devolution down to the local level.
Just one other word on that. I mean, the 287G agreements do precede the executive orders. 287G is referring back to a provision of the statute, the INA. And we have some precedent to look back on the way that those 287Gs have operated in the past. There was a lot of attention given to them back in, was it 2010? Yep. When Arizona's SB 1070, their state legislation, came to Supreme Court litigation. And one of the results of that litigation was not that 287Gs were found unlawful, but that in practice they were being far less heavily relied upon under the Obama administration, but they remained available within the statutory framework. So in some ways, this would just be a resuscitation of a program. And as Professor Hall spoke about, that's true for a number of the other crime-related provisions as well. I mean, the return to sanctuary, secure communities, for example, is a return to a program that existed before. So some of this is unprecedented, some of it is precedented. And so, you know, it's worth looking to see what happened before, understanding that we are at a different point.
Right. I mean, the 287G agreements had a lot of problems in a lot of the jurisdictions where they were. I mean, Obama ended up rescinding the 287G agreement with Arizona, Maricopa County, because Joe Arpaio was, the human and civil rights violations were just coming out. They couldn't sustain it any longer with a straight face. North Carolina had a 287G agreements in a number of their jurisdictions, and they were hit with so many lawsuits, and they had to pay out so much money in fees and lawyers that it seems to me that North Carolina, for example, would be hesitant to go back to that, right? Given that they had so many internal problems and issues and litigation surrounding them to begin with. And so they've got definitely history to learn from.
And I think that's what's disturbing about this order, to me at least, is, you know, these aren't all brand new things. These are things that have been tried before and that haven't worked, not just from ICE's perspective or just from the federal government's perspective, but from the perspective of local law enforcement. Local law enforcement doesn't want to be engaging in federal immigration law enforcement. But this order is saying you either have to do it or you need to at least think about doing it. So, you know, we're kind of just going backwards to an earlier time when things weren't working from anyone's perspective.
So the Ninth Circuit had a decision on the temporary order that could be appealed, but how is the rest of the lawsuit for the actual, like, how does that work? Because the judge, has any judge ruled on that? I don't know.
Right. Do you remember from civil procedure that, well, I don't know if you covered temporary restraining orders or any sort of injunctive relief at all, but to get those, they're considered extraordinary relief. So you have to make some initial showing about the likelihood of success on the merits. So you don't just get one because the risk of harm is sufficient. You got to show some likelihood of success, but the actual litigation of the underlying claim won't happen until after the injunction gets resolved, right? That goes up and then we'll come back around on the merits, unless I suppose the Supreme Court could choose to take up the merits as a way of being expeditious. That would be pretty extraordinary, but the Supreme Court could choose to do that.
So as I understand it, from the lawsuit that from the decision in the Washington case that came out Friday, as I understand it, just reading the commentary from the weekend, there's a couple different options on how that lawsuit could proceed, and it's not clear which one it will take. So one, as Professor Cantrell said, would be to beyond the TRO to continue to litigate on the merits, and that would go to a permanent injunction sort of issue. Another is, and I believe the last word I had seen was that the Ninth Circuit has already called sua sponte for an en banc rehearing. So that's sort of an intermediate level.
One judge hasn't voted yet, so en banc hasn't been granted.
Right. Okay. So they're accepting briefing on that right now, from my understanding. It's a little bit unusual for that to happen sua sponte. Typically, it's the losing party that would request an en banc hearing before moving to a higher body like the Supreme Court. But that's one or 80. But again, that will be on the TRO question, not on the underlying merits of litigation. And the other options, again, are with the Supreme Court, or the other option that has been talked about in the news is whether or not the Trump administration will issue a new version, presumably a more narrowly tailored version of the executive order.
Which would potentially
Which
make
would,
right the
I
idea
assume,
to
loop the litigation.
Well, and it's worth maybe emphasizing some of the other things that might happen in the meantime if they decide to go down that road, or even while they're mulling whether to go down that road. One thing I've been following closely is that the Department of Homeland Security has posited that Customs and Border Patrol agents may, for example, start collecting or demanding social media passwords from people coming into the country, seizing electronic devices, that sort of thing, and start doing some, some version of extreme vetting that they've talked about. So there's a number of things that could happen, kind of short of the case going up to the Supreme Court and getting resolved once and for all. And it's not unlikely that it's an immediate path.
Other questions?
We all think because it's noticed that likelihood of either majority
And again, I think some of it's going to, reading the TV is
Yeah.
always dangerous. We should say that first. But one thing to recognize is that some of this, I think, again, goes back to what Professor Cantrell was pointing. It depends what issues are being certified at the time that the Supreme Court intervenes. In the more short term, if the Supreme Court's decision was being sought just on the temporary restraining order, the current composition of the court is 8 judges, right? And so I think word on the street, which is all that that's worth, is that we have a fairly evenly divided court on related issues of executive authority and immigration rolling over from the last term. And so on the TRO, I think the word on the street is the likelihood is that if it were evenly divided at 4-4, that would leave in place the Ninth Circuit TRO decision to keep in place the TRO. If, on the other hand, the Supreme Court were to take up the more merits-based arguments, that would take longer, right? Typically, that would be calendared late into the spring, possibly next fall, at which point we may not have 8 people on the court. In all likelihood, we would probably have a full 9-person court. And then I don't know how that gets decided.
Right. I think the language that both, I think, Professor Chapin and Professor Chen noted the statutory language about that delegates to the president certain scope of authority. That's tricky. That you're litigating, has Congress said, President, you get to do this realm of stuff. That's an interesting fight.
Right. I think you get kicked on standing issues. So I'm just saying that the states don't have standing as parties who are harmed by this ban. That would be what I think Roberts would do.
Although, one thing I think is interesting about that, and if there aren't more questions coming from the audience, at least one that I might pose for you all to think about, is how these different bans, how these different executive orders do affect our life on this university as a campus. And I guess the tie-in being that one of the arguments that has been made is that perhaps one of the reasons that there's been less attention to the standing issue in the Washington case so far is that so many state universities can show harm in the number of international students and scholars who have already been impacted by the travel ban. So unlike the Texas versus United States litigation last year over the DAPA program, the Deferred Action for Parental Accountability program, where there was arguably a more tenuous claim about whether or not states issuing driver's licenses at a financial loss to the state to those who were eligible for DACA. That standing question, ultimately, we don't know what this court decided because, again, it ended in a deadlocked decision. But I think there was a lot more uncertainty there than potentially there is here, at least on the working assumption that harm is being felt.
And just for the non-lawyers in the room, the question of standing is the idea of to have the ability to go in court and sue you, the plaintiff, whether it's you, a person, or an entity, has to show some actual harm, simplifying. And so the question is, can states show that they're actually being harmed as a state by the executive order?
And then just to go back to the political point, and we're sort of assuming that any case on any of the doctrines that we're talking about is going to proceed according to how they have been litigated before. We are dealing with a president who has wrapped up in the outcome of this case the legitimacy of the judiciary, and talked about so-called judges and all of that sort of stuff. And it will be interesting to see if that, the sort of magnitude of that challenge affects how the case proceeds and how the judges think about it.
You said that like the sanctuaries that refugees are currently at would be affected possibly by the order that you talked about. Could you explain that a little bit more? Would they be shut down? Or
So just to be clear about two different concepts. So you asked about refugees.
yes, the refugees have been clear refugees for now and foreign entry.
Okay.
How you said before they sometimes
In safe places.
it's safe places. It's not like sanctuary cities.
Okay. I think it was actually Professor Chen who was talking about refugees outside of the country. So maybe we can ask her to answer. The question is, like refugee camps, is there any talk of those being shut down? Are the safe places where the refugees were supposed to be able to go, that they were being denied admission?
For the states. I don't, so I don't have deep expertise on that. The small point that I was making was that I know in the earlier draft of the executive order, there was discussion of a particular safe zone within Syria that is not included here. So like I said, I don't have deep knowledge there. I think Norm Aronson just left. He might know more than me.
Yeah.
But I think generally speaking, at least on the face of the executive order, it's not clear that safe zones that have already been established outside the country would necessarily be affected. It's more about at the point of entry, whether or not people would then be admitted.
In terms of the president's authority, right, he can't shut down a refugee camp in Kenya or anything like that. So when people are outside of the United States and they're not seeking entry, then generally that's going to fall outside the scope of this order.
You can't shut funding down.
Right. That is true. That is true.
Yes, sir.
Well, I had a question. This is kind of an old school question I got. The way I understood it was, you know, a president's executive order concerning a national security matter is law, and it is valid, and it can't be gone into while it's, see, this is old school, like I'm saying. It can't be gone into while it is active. Once it is not active, persons who feel aggrieved by the, you know, the action, including constitutional claims, could then come into court and bring their damage actions at that point. But that's the way I thought it used to be. But now we have this whole new field of injunctions against the President of the United States. That's new for me. You know, I don't know about other people, but they didn't used to be able to go in and do that, to my memory, but maybe I'm wrong. This is obviously a field that's been developing for years. I haven't been looking at it, but I think there's a big change here. I don't know what's going to happen. You know? So what's my question? My question is, isn't it true that as a general rule that you can't go into that order, that executive order? You know, President Lincoln suspended habeas corpus. Nobody took him to court over it. Of course, maybe they didn't think of it. You know, but I'm just saying, there seems to be one side of the country, or one side of the legal community is saying, we're in shock because a court can't do this. And then there's this other section, newer people, I think, say, sure, there's no problem. If he violates somebody's constitutional rights with by the overbreadth of his, actions, we can take him to court and shut him down.
I think you've highlighted a really interesting question that is at the heart of separation of powers, and that's which branch has the authority to do what. And so often these fights are about, if the executive branch has authority to do A, is what the executive branch did an example of A, or is it pretending it's an A, but it's actually something that should be done by Congress? And so some of what you're seeing here are fights over is what happened here in the prerogative of the executive branch, or has it been used, has this president usurped something And that's the fight. That's the very fight. And so Article 2, 1, 2, and 3 all, give certain jobs to each branch of the government. And the fight is who stepped on, did anybody step on somebody else's toes? I mean, to simplify it.
And this certainly isn't the first time that we've seen this. I mean, President Obama, when he issued deferred action for childhood arrivals, for example, 2 years later, he tried to expand it and issue another executive order, deferred action for parental accountability. And that, many Republicans screamed, you are invading in the province of Congress. Like, you are acting outside of your role as the president. You can't do that. And they did sue him in Texas in district court, and they stopped that from going forward. They were able to, they got a judge to enjoin it. And the Fourth Circuit wouldn't lift the stay. And so it stayed, it went up to the Supreme Court, got a 4-4 split, and it stayed where it was. So this is definitely not new in terms of these things happening. And it's exactly what Professor Cantrell just said, which is somebody objects and says the president is acting outside of his jurisdiction as the president, because that is something that is supposed to be left up to Congress, to elected representatives to decide that. So that's what we're seeing here, is people are objecting to this, to sort of what he's done unilaterally as the president, saying you can't do that. There's different objections to what he's doing, but that's sort of where we are.
I can just add one other.
People that say yes, you can.
Right. Well,
if I can just add one other quick gloss to it. I mean, I think one of the things that makes your question even more interesting is that when you talk about old school or the new approach, I think there's an interesting wrinkle where we are talking about not just the rights of people, but the rights of non-citizens. And so this old school approach that you're talking about is actually, I think, if anything, amplified in the example of immigration law, right? And so we have at least one of my immigration law students in the room who might be bored by the recitation of this. But one thing you hear a lot about is immigration exceptionalism. I think you hear about national security exceptionalism. I think that's some of what you're talking about, is that we do have these particular zones of the law. And at least some, including President Trump in the Ninth Circuit argument last Friday, was pretty squarely arguing under the authority of cases going back to Che Chenping, the Chinese exclusion case, evaluating legislation from the 1880s. Right? There's been a lot of references to to FDR's executive order ordering the Japanese internment on the basis of national security grounds. There are a lot of legal precedents that show a very high level of executive authority when we're talking about areas of immigration, especially at the initial entry point, which is what this executive order that we spent most of our time talking about goes directly toward. So there is a lot of authority to that. But I do think that part of the old school approach that's still there too, is that it's a question of authority and the limits on that authority, right? And so I think we've been talking just now about the separation of powers limitations. A lot of the litigation that's been raised so far is about the individual due process limitations, which are admittedly quite a bit weaker for non-citizens than they are for citizens. But the course of that same series of cases, going back to the 1880s, has been to show plenary power does exist, subject to limitations that are being increasingly well-defined through either the due process claims or the separation of powers claims.
Okay. I don't see how a president can govern everything he does. Suppose he's not very popular. There are like, how many circuit courts are there? How many, not circuit courts, but federal district courts? How many are there? I don't know, but there's a buttload. So if every time he does something, somebody files a lawsuit and the judge is sympathetic, issues a basically permanent restraining order in the form of a temporary restraining order, and the thing can't even be challenged in a higher court because it's not final, how do you govern if you're, stuck with that? I guess we have to hope that people bringing these suits are bringing them in good faith, which I read it and it sounded pretty good, because there are, discredited documents like Korematsu, that are really no longer law, and so if the president tries that, can you cut him off, so anyway, it's certainly an interesting case, but I don't know how it'll turn out. But thanks for coming.
Thank you for coming.
Yeah, it's great.
I do think there's some of us who need to leave and maybe others who can stay. maybe can say, I don't want to speak out of turn, but for those who have other obligations.
Well, are there any other questions, or maybe we can let our panelists go?
Just ask one short question. With the fact that I expect that our enrollment applications will drop substantially just on the basis of what's happened already. For example, I don't expect to see any students coming around for next fall. And certainly in our case, at least one of our very best students from there. So I don't know whether the university can claim that as damages or not. They have a hard time showing that your numbers from these 7 countries and other Islamic countries might drop in half or something. Can you claim that as damages or not?
And that was part of the showing of standing that the state of Washington argued was exactly what you are saying, that the ability to recruit top students, and particularly in fields like electrical engineering and computer science. So that's certainly been part of the argument. And just for your interest, I think I remember you saying at the beginning you're from electrical engineering. There have been some efforts internationally to set up programs that help students, promising students from those countries that were planning to attend PhD programs, to find residence elsewhere while this all sort of gets worked out. So if you have really, really good students that are displaced by that, come, let's chat. There's people are trying to solve this problem in other ways. So.
I just wanted to make a comment on that because I'm the international student scholarship. So there are percentage of students from those countries that are really new applicants coming in, but I can just cite from practical experience. A lot of, especially in the PhD programs, a lot of them are already in the U.S. It's not uncommon, especially in Iran. A lot of people come and they do their undergraduate, their master's, and their PhD. So yes, there is some impact, but the good news is that, especially here I'm seeing, a lot of them are transferring from other schools. So hopefully that population won't be impacted as much.
Well, if there's no more questions, please join me in thanking our panelists.
Thank you guys for coming and being interested.